Hello, beautiful people. This is my first time ever live on YouTube. So I hope we get some people on here to join us live as we discuss the latest policy update by USCIS. I don't know why there's no banner for this. Latest policy update on conditional residency. Okay, so now let me add this so that this shows up. Okay, wonderful. Great, great, great. Okay, so you're all very welcome to this live video. For those of you who are new to my channel, my name is Attorney AK or Akua, and I'm a U.S. licensed attorney. I focus my practice on U.S. immigration, representing immigrants in all 50 states throughout the United States, and we handle all types of U.S. immigration law matters. So there was a release by USCIS this morning on conditional residency. So we're going to go over the latest policy update and look at what this means for you if you're a conditional resident, and more specifically those who obtain their conditional residency through consular processing. Okay, so let me share my screen with you and we'll jump right into it. I would have to zoom. Okay, I think it looks fine. I don't even have to zoom in. It's all bright. Yeah, very bright. I like it. Okay, so this morning, as I said, there has been an interview waiver criteria that has been redefined. So the last time this was redefined was in 2018, and there is currently a 2022 policy guidance that is going to guide USCIS on how to conduct interviews for conditional residents who are attempting to remove the conditions on their green card. So we're going to go into the details, okay? Okay, so normally a non-citizen or foreign national, if you obtain permanent residency, that's a green card, and you get that status based on your marriage, and your marriage is less than 2 years at the time you obtain the status, at the time your green card is approved, your first green card is approved, then you're going to get what is known as a conditional green card. The only difference between a conditional green card and a permanent green card is that the conditional green card is only valid for 2 years. It's conditional in nature. And so you have to file 90 days before the expiration, you file to remove the conditions. The difference is if your marriage has been more than 2 years or 2 years or more at the time of the approval of your first green card, if it's based on marriage, then you're going to get a 10-year green card, okay? Once you get the 10-year green card, then all you need to do is at the time, before your green card expires, normally 6 months before, then you can just file an I-90 to renew it. However, if you have a conditional green card, you cannot file an I-90. That's one main difference. You file what's known as an I-751. It's an application to remove the conditions and to show the U.S. government that your marriage was bona fide and, now you deserve a permanent green card, right? Okay, so that's the background. Now, to remove the conditions on permanent resident status, family-based conditional permanent residents generally must file a petition to remove the conditions on their residence. Okay, as we discussed. And normally, the Immigration Nationality Act requires that persons who are removing conditions on their green cards appear at a USCIS field office or before an interviewer to actually partake in an interview, and if everything checks off and everything is fine, then the conditions of that green card will be removed. Now let me scroll down some more. We're done with this first part. Okay, guys, welcome. I hope I welcomed all of you to this live video. We're just discussing the latest policy updates by USCIS. Okay, now as I stated, the INA requires you to appear for an interview with your spouse, especially if you're filing a joint petition to remove the conditions. This is found in Section 216C1B. However, at the same time, It also gives USCIS the authority to waive interviews for some people. Okay, so we'll go through the conditions under which USCIS may waive your interview if you're a conditional green card, filing to remove the conditions from your green card. Okay, we'll go through that. So the INA, okay, we've discussed that. The INA also provides USCIS the authority to waive the interview. And in November 2018, what happened was that USCIS came up with a new guidance, and it limited the circumstances under which an interview could be waived. So what they said was that if you obtained your conditional permanent residency status through consular processing, which means that the conditional resident or the foreign national or the non-citizen was not based in the US at the time of filing. That means he was based abroad. His spouse or her spouse was based in the US, and then they filed the first part petition for alien relative here that was approved, the I-130. And then the second part was done via consular processing, meaning that the other spouse went to the US embassy, went for an interview, fill out the DS-260, all the forms and all of that, and went to get interviewed before a consular officer. So if you got your conditional permanent residency through consular processing, then when it's time for you to remove the conditions from your green card, then you are not going to be allowed to waive that interview. So USCIS was not allowed from 2018 to waive interviews for people or persons who had obtained their conditional permanent residence status through consular processing. Okay, but now that policy guidance has been overturned, and this current policy guidance actually supersedes the previous ones, which means that now consular processing is no longer a barrier to conditional permanent residence interview waivers. So the fact that you obtained your green card, your conditional green card through consular processing does not mean that you are automatically eliminated from getting your interview waived, your I-751 interview waived. So it means that even if you obtained your conditional permanent residency through consular processing, so far as or as long as you qualify to have your interview waived, your interview is going to get waived. Now, consular processing will no longer be a barrier to getting your interview, your I-751 interview waived. That's your removal of conditions interview waived. Okay, so I hope that's very clear. Updates. Okay, so this policy, let's talk about the policy highlights. The first one is that it updates the interview waiver criteria by providing that USCIS officers may consider waiving an interview if generally the applicant meets the eligibility requirements the record contains. Okay, once you meet the eligibility requirements, then your interview could be waived, even if you obtained your conditional residency through consular processing. The next thing is that let me pull this up again. Okay. So far as you have sufficient evidence and there's no indication of fraud, misrepresentation, criminal bias, or other factors that may require an interview, then they're free to waive it. These are the policy considerations the USCIS is going to use to determine whether or not they're going to waive an interview, and not whether, how the conditional permanent residency was obtained, whether through consular processing or through an adjustment of status here in the US. So then last thing is that the policy highlights updates interview waiver criteria to eliminate automatic referrals for cases where a CPR, that's a conditional permanent resident, obtained status via consular processing, and to refer CPR cases based on the risk-based criteria. So they're going to be looking at the risk-based criteria, not whether it was via consular processing or via an adjustment of status. So now, let me take this screen off. Now we're going to be taking a look at what the actual, let me remove this, the actual criteria for waiving interview, so that you make sure that once you fall within this, then you know that you can get your interview waived. Once you prepare a very solid case, then you know that your interview could be waived for you. Okay, chapter 3 of the USCIS policy manual. Let me pull this. Okay, this is great. Okay. Okay, no, we won't go into. We'll just discuss this, the relevant portions for today. Okay, so conditional permanent residents who file Form I-751, as I told you guys, they must appear for an interview at a USCIS field office unless USCIS waives the interview requirement. USCIS officers, here is a criteria. They may consider waiving. Well, here are the criteria. Well, it's actually, you have to satisfy all the five elements, one, two, three, four, five, all the five elements together. So USCIS officers may consider waiving the interview in cases where, number one, the officer considers they can make a decision on the petition based on the record because the record contains sufficient evidence about the bona fides of the marriage and that the marriage was not entered into solely for the purposes of evading immigration laws. The second thing is that there's sufficient evidence in the record of the CPR's eligibility for waiver of the joint filing if applicable. So if you're filing a waiver, you need to demonstrate the bona fides of the marriage. Again, first one, you need to demonstrate that marriage was entered into for the purposes of establishing life together, not for a green card. Okay, then thirdly, there's no indication of fraud, no indication of misrepresentation on the I-751 in the supporting document. So they shouldn't have any type of indication or suspicion that there's fraud or misrepresentation on the form. And then there are no complex facts. If there are complex facts and issues that require an interview, sworn statement to resolve questions or concerns, then you will be called for an interview at a USCIS field office. And the last thing is that there are no criminal bars rendering the CPR removable from the United States. Okay, so normally when determining whether to waive an interview, the considerations listed above apply regardless of whether I-751 is filed as a joint petition, individual filing request, or a waiver. So even if you're filing this as a waiver means that you're not filing along with your spouse, you're not filing together. If you're filing a joint petition, then the US citizen or the green card holder spouse will have to sign the I-751. If you're filing as a waiver, then you're filing based on divorce, abuse, or death. And so you're filing independently. Okay, it's a sort of like a self petition. For a joint petition, the statute requires USCIS to interview both. So if you're doing a joint petition, they'll call the conditional permanent residence and the petitioning spouse. But if the CPR, the conditional permanent resident, is actually doing an individual filing request or waiver, then it's only the CPR, the conditional permanent resident, that must appear for the interview. All right, friends. So that is the policy update. I hope you guys have benefited. It's I've done an extensive review of the latest guidance by USCIS this morning. Please let me know in the comment section if you have questions, concerns, and hopefully I will be able to address it in the next video. Thank you so much for joining. I will see you guys in the next video soon. Okay, take care and be safe. Bye-bye.